Now, that's not to say that each case cost hugely more than were there multi-party actions, but it may have been possible to handle them more speedily, as indeed I believe Shirley-Ann Somerville argued in her contribution. Several members mentioned Mackenzie Friends. Dave Whitten, I think, concentrated his contribution largely on that. I'm sure he will know from his own reading of the Gill report, that the consultation responses on the issue of Mackenzie Friends was mixed, but that the recommendation which the Lord Justice Clerk has made is for entitlement of a supporter to address the court with permission of the court, as is allowed already in the Sheriff Court, summary cause and small claims. Cathy Craigie was concerned not to rush change and to involve Parliament. Paul Martin finished by asking if we would discuss how we go forward with stakeholders. Certainly we have an open approach, as members know. We will engage with stakeholders as is required. I think, however, it's important just to place on record the fact that before this report was produced, there were 200 consultation responses. In other words, there has already been the most substantial and thorough consultation exercise. It would be an act of duplication to start that process again, but I don't think anyone is advocating that that is how we should proceed. Ross Finney talked, I think, almost exclusively about the Aarhus Convention, and I would ask that he acknowledge that there are different legal views on the topic. For the record, we do not accept that the Scottish rules are not compliant with the Aarhus Convention or EU Public Participation Directive, and that justice in Scotland is not non-compliant in that regard. However, ministers have raised already with the Rules Council the potential for better application, specifically considering use of protective cost orders. And Ross Finney, again, I expect, as someone who is undoubtedly familiar with the extracts from the 700-page report, may well favour the Australian model of proceeding in that regard. But no doubt time will reveal all. Certainly.
David Whitten.
For giving way. If I can just bring him back to my comments about Mackenzie Friend. He mentioned that there was wide consultation on this and varying reports about its effectiveness. But I'm sure he would also recognise that Lord Gill is firmly recommending that this should be implemented. And indeed, it already works in jurisdictions south of the border. So I really don't see why we need to delay too long before we implement this particular move.
Thank you. There are too many conversations taking place in the chamber at one time. Please, I'd like just to hear the Minister.
Yes, thank you, Presiding Officer. I mean, David Whitten is absolutely right that the recommendation is that Mackenzie Friend should play a role in Court of Session actions. I think it's also fair to point out, however, that my understanding of it, my recollection of reading that part of the report, is that there are caveats, that it should be up to the discretion of the judge handling the case to ensure that that is appropriately handled for each case. It's not an easy matter being a Mackenzie Friend, and particularly if it's a complex case, there could well be issues surrounding the appropriateness. I think it's also the case that Lord Gill states that in family actions it may not always be appropriate for example, a family member to act as a Mackenzie Friend because of the inevitable issues or potential conflicts of interest that may arise. Presiding Officer, many members devoted their contributions to talking about the risk of denying access to justice to individuals. I think Cathy Craigie made comments on that effect. And there was perhaps a suggestion creeping in that somehow there would be a conflict in adopting those recommendations of the Lord Gill report which seek to bring about greater efficiency, to reduce the delay and to control costs on the one hand, and on the other hand ensuring continued access to justice. I don't believe that that conflict exists in the way that it appeared to be presented. In fact, the opposite is the case. I would submit, Presiding Officer, that the system we have at the moment is causative of huge, inordinate and unreasonable delay. That's precisely the point that Lord Gill makes. If one reads the chapter on inner-house court procedure and the research by Dr. Rachel Wadia, for example, you will see that the estimates by QCs and advocates, presumably, of the length of time it takes to conduct inner-house court proceedings are so wildly out that, quite frankly, the percentage success that they had in estimating how long it was going to take to argue cases before the inner house were actually lower than you would expect if you went into a bookies and selected a horse at random from any race of the day. Now, that doesn't seem to me, Presiding Officer, to be a satisfactory way to conduct a legal system, and I hope that all members, Presiding Officer, would agree with that. And therefore, justice delayed is justice denied, and for far too many people that has been the case in Scotland. Presiding Officer, in concluding, may I, on behalf of the Government, express our grateful thanks to Lord Gill for this massive oeuvre that he has provided to us. I can't really recall any case where we owe such a debt of gratitude, although we have had many weighty tomes provided to us over the years. I think thanks is also due to his three colleagues on the board, Lord McEwen, Sheriff Principal James Taylor and Sheriff Mary Stephen. I am confident, in conclusion, Presiding Officer, that this report will help us deliver a modern, fairer and far more effective civil justice system in Scotland.